Good afternoon. Welcome. Thanks for joining us. My name is Nell Brimmer. I'm the managing attorney of client access and pro bono here at Legal Services Alabama. And this is the last CLE in our Celebrate Pro Bono CLE Celebration Week. And I'm really excited about today's topic. It's air property in Alabama. And we're joined by two LSA attorneys who have done work in this area and are happy to share their expertise with us. So let me go ahead and introduce them. First up is Valynda Jerome-Williams. She joined LSA in August 2017 in the Montgomery office, working specifically in the area of domestic violence. She then transferred to Mobile in 2018, and now she specializes in a wide range of public interest work across various demographics, including consumer law, housing, family law, air property, and estate planning. We are also joined by Will Breland. Will is currently an elder law attorney in our Tuscaloosa office and joined LSA last year as a board shard fellow. And I will say for both of them that they have, Will has been published in Air Property Matters, and we've shared that article in one of the handouts. And Valynda was a recipient of the Isaiah J. Whitley Legacy Award. And that was given by the Mobile County Training School Alumni Association in Africatown. So I'm gonna go ahead and turn it over to them. Valynda, if you wanna get started. Thanks so much.
Absolutely, thank you, Nell. All right, we will talk about air property. What is air property and how to spot it to get us started. Lots of people want to know, what is Legal Services Alabama? Legal Services Alabama is a nonprofit civil law firm that provides civil legal aid to low-income people and promotes collaborations with community partners to find solutions to problems of poverty. We serve all 67 counties with offices throughout the state, including locations in Mobile, Montgomery, and Tuscaloosa. We only handle civil cases. Each office has attorneys licensed to practice in the state of Alabama and staff who know how to help low-income people resolve legal problems. We provide representation on critical legal matters in judicial and administrative forums, timely legal counsel and advice, community education about rights and responsibilities, effective mediation services to keep disputes out of court. In addition, we develop and distribute legal self-help materials and forms. So what is air property? Air property is land that is held without clear title. It is also called grandpa's land, heirs property, tangled title, family land, common land, clouded title, and array of names. Heirs property is known as, and it is spelled many different ways, including heirs and heirs' property. However, it is not spelled or known as A-I-R-S, heirs property. Heir property is real property once owned by someone who died intestate, inherited by more than one heir of the deceased, who have a fractional interest in the deceased property and property that has encumbered title as a result. Our Alabama Uniform Partition of Heirs Property Act defines heirs property as real property held in tenancy in common status, where there is no agreement in the record binding all co-tenants, which govern the partition of the property, where one or more co-tenants have acquired title from a relative, regardless of whether that relative is living or deceased, and where any of the following applies. 20% or more of the interests are held by co-tenants who are relatives. 20% or more of the interests are held by an individual who acquired title from a relative, whether living or deceased, or 20% or more of the co-tenants are relatives. So what is the problem with heir property? As attorneys, you may have heard about heir property. Heir property opens Pandora's box to a plethora of issues for heirs, including land disputes, unsecured title, land loss, the heirs being at risk of being ineligible for some municipal, state, and local grants to improve the land, heirs having difficulties locating other heirs, especially when there are over 100 heirs, and some other issues, including widening the wealth gap between those not most adversely affected by heir property and those communities who are most affected by heir property. Working on heir property issues is a niche area of law. However, heir property is an issue throughout the country. There are lots of heir property issues throughout the South, and African American communities are most affected by heir property issues in the South. And why is that? Well, when we look at the history of land laws and land ownership in the African American community, we can see why. At the turn of the 20th century, African Americans began to purchase a lot of land, mainly farmland. And at one point, African Americans owned approximately 15 million acres of land. Due to various reasons, including the social climate of the country, a black code, Jim Crow laws, etc., many African Americans moved from the southern area of the country to the northeast, Midwest, and western parts of the country, oftentimes leaving their land behind. Over time, African American owned farms reduced significantly, and currently there's under 5% of farms in the US owned by African Americans. From the early 2000s up until where we are now, we've seen the African American communities try to reclaim land, try to build home ownership, although with some setbacks. There has been more attention now placed on estate planning and cleaning up heir property. In African American communities and many other communities most adversely affected by heir property issues, we get to talking about heir property because the landowner did not make a last will and testament during life or create some other type of legal instrument to pass the property legally to someone else. In African American communities, typically land passed by oral tradition, or there was an cultural understanding that the eldest son would inherit the land. A will, also known as a last will and testament, is a legal instrument a person makes to distribute his or her estate to a beneficiary or beneficiaries upon his or her death. In Alabama, a person 18 years or older and of sound mind may make a will. The will must be in writing, signed by the testator, that's the maker of the will, or in the testator's presence and by his direction. In addition, at least two persons, each of whom witness either the signing of the testator's acknowledgement of the signature or of the will, shall sign the will. A person with a last will and testament dies testate, and a person without a last will and testament dies intestate. And we see intestate land ownership happening a lot in the African American community and in other communities, and that's why heir property becomes an issue. Heir property results when there is no last will and testament, deed, or trust put in place to transfer real property from the deceased landowner to another person or heir. When we have no will in place, the laws of intestate succession apply. And Title 43 of the Alabama Code, Section 43-8-40, specifies that any part of the estate of the decedent not effectively disposed of by his will passes to his heirs. The deceased's estate passes according to civil law, and we can see that here depicted by the Nolan chart. We're going to start with the spouse and the children, and depending on who is alive, who survives the deceased, also known as the decedent, the estate may descend or ascend to other heirs. So how does this look? Well, when the decedent dies and has a spouse, then section 43-8-41 specifies that if there's just a spouse that survives the decedent, the spouse inherits everything. If the decedent is survived by spouse and children who belong to the decedent and the spouse inherits the first $50,000 of the estate plus half the balance of the intestate property, and the children inherit the remaining intestate property. If the decedent is survived by a spouse and children who do not belong to the spouse inherits half of the intestate property, and the children inherit half of the intestate property. And if the decedent is survived by a spouse and parent, the spouse inherits the first $100,000 of the intestate property plus half the balance of the intestate property, and the parents inherit the remaining intestate property. Title 43, Section 43-842 specifies how the decedent's estate passes to heirs other than the surviving spouse. And as you can see here in subsections 1 and 2, the issues of the decedent will take and share equally if they are of the same degree of kinship, and if they are of unequal degree, then those of remote degree will take by representation. Subsection 2 states that the parents or surviving parents take equally if there is no surviving issue or surviving spouse that survives the decedent. And this is how that looks. A dad that is deceased, no spouse, his children, C1 and C2, will inherit. That same child going all the way over to the third chart, that third child with no spouse and no issue, we can see the estate is going to ascend up to the parents, parent 1 and 2. Under subsection 3, if there is no surviving issue or parent to the issue of the parents or either of them by representation, and we see that here, child 2 is deceased, has no spouse, has no issue, and parents are deceased, so we have siblings who stand to inherit. And then subsection 4 says, well, if we do not have a spouse, no parents, no issue, the estate is going to go up to the grandparents' line or their issue. And we see that depicted here. Of course, this is where we can get into lots and lots of other heirs who stand to inherit when we have a deceased grandparent or both grandparents are deceased. There is no spouse, no children, and parents are deceased as well. Title 43, Section 43-8-44 says, if there are no heirs to inherit the decedent's estate, eventually the estate will escheat to the state. That means we would have exhausted all of these folks on this chart before the property escheats to the state, of course, barring any other type of interference, such as a tax sale situation where the land is sold to the state for taxes, for back property taxes. We've been talking about heir property. We've mentioned heirs in passing. However, who really are the heirs? The heirs are persons, including the surviving spouse, who are entitled under the statutes of intestate succession to the property of the decedent. That means our potential heirs include the spouse, issue, parents, siblings, grandparents, family members related through grandparents, aunts and uncles, cousins. The law presumes an heir is someone who survives the decedent by 5 days, and the law presumes that a decedent has a next of kin living somewhere in the world. So we expect that someone is going to show up and express an interest in the heir property. The makeup of heir property can look differently from case to case. Some cases are rather straightforward with relatively few heirs. However, other cases can contain over 100 heirs, and this can really make resolving heir property issues time-consuming and costly. Here's an example of an heir property case. This is similar to a case I recently completed that involved 20 heirs. I wanted us to walk through it. In this example, we have C9, which is child 9, that wants to, or a survivor of child 9 that wants to clear title to heir property in 2021. The hypo assumes that the parents had 9 children, all in common, and that 3 children are deceased, and those children died single and intestate with children. So let's look at the interests of the heirs. We see dad died in 1975 and mom died a widow in 2013. They had 9 children, looking at the first line, because when we're looking to determine heirs, we're going to go to the first line of where a living person exists. And that is going to be the line where we see C1 through C9. C1 is deceased as of 2014, C5 is deceased in 2016, and C9 is deceased as of 2020. And so we have C9's issues coming to us trying to clear title to heir property. So when we look at the interest, we see C2 through C4 and C6 through C8 all have a 1/9 interest in the property. And we see the grandchildren, GC1 through GC5, they will split the interest that C1 would have had, that 1/9 interest. They're going to split that. They will have a 1/45 interest in the property. Then we go over to C5, who has 3 kids, and so GC6 through GC8 will each have a 1/27 interest in the property, and GC9 through GC12 will split C9's 1/9 interest, and they will have a 1/36 interest in the property. And when we combine everyone's interest, all those heirs' interest in the property, we will come up to one whole. So I was talking about the different interests that each group of heirs will have here. And when we add all of this up, this will come to a whole, a one whole. Here we have James O. McDonald, who owns 4 acres of land. He has 4 children. If he dies without a will, also known as intestate, his heirs are living, his children are living at the time, then each child will have a 1/4 share or 25% interest in the land. Heir property has been in the news lately, and we have heard stories about Hilton Head in South Carolina. It's a well-known resort destination. This area was occupied by the Geechee Nation, and they bought a lot of property there. And there was the great-grandfather of Matthew Allen, Dennis Allen, who bought nearly 20 acres in his first parcel of land in the Hilton Head area back in 1897. Over time, developers have come in and purchased the property, or the family has lost some of the property, and other people in the Geechee Nation have lost property and have had to move. However, the Allen family still own the largest lot of undeveloped land in the Hilton Head area. There are over 100 known heirs of the original owners, so they are all co-owners. Here's the thing, with 100 known heirs, that's just the known heirs. We don't know how many unknown heirs exist. And when we're trying to resolve an heir property matter like this, it can be timely It can be time consuming and it can be costly. You may have also heard about the California heir property case. And sometimes as attorneys, and we'll get into this later, we think of certain ways to resolve heir property, but sometimes just being an advocate to legislators or to other people in authority can really help to push heir property towards a resolution. Here we have Dwayne Yellowfeather Shepherd. He's an extended family member of the Bruce family of Bruce's Beach. Now, his family owned land a century ago. They owned beachfront property. They had a resort with a restaurant, dance hall, and changing tents. His ancestors were run out of Manhattan Beach and forced to shut down. The city seized their property, at one point built a park on the land, and the Bruce family lost their fortune. On September 30th of this year, California's governor signed a bill into law granting the county permission to transfer land back to the Bruce family. Now, I think this is so many decades removed from when they first owned that property. No one who was living at the time is able to see this property come back to the family, and the property is now worth millions of dollars. So think about everything that family could have experienced over time. Wealth gap, poverty, trying to sort through heir property, perhaps litigation to try to get the property back. As practitioners, as attorneys, it is important to know what is heir property, to know the laws of intestate succession, to know who constitutes as an heir, but it's also important to know heir property when you see it. So how to spot heir property? This is the attorney's heir property checklist, and feel free to add to it. We want to ask, is the property owner deceased? Did the property owner die intestate without a last will and testament? There is no deed that's transferred the property. There is no trust that has the property in it that has transferred the property. We want to ask if the deed remains in the deceased owner's name. Is the property held in tenancy and common status? Is there no agreement in a record that governs partition? Did one or more co-tenants acquire title to property from a relative? And does any of the following apply? Are there 20% or more of the interest in the property held by related co-tenants? Is 20% or more of the interest held by individuals who acquired title from a relative, whether that relative is alive or deceased? Or is there 20% or more of the co-tenants that exist that are relatives? Regardless of being able to spot heir property, knowing what heir property is and who qualifies as an heir, and the laws of intestate succession, resolving heir property can be time consuming, it can be costly, but the benefits to the family and generations of family members is priceless. And so this is an area that we encourage attorneys to consider getting involved in, because a lot of what we do, we don't really see so much benefit all the time, but knowing that you have really changed the course of an entire family, the path, the trajectory of land ownership, wealth building can really make a difference, and can really make a difference, and it will be very valuable to you as a practitioner. So what resources are available to help resolve heir property? I'm going to kick it over to Will.
Okay, so for my first slide, we can go to the next one. So why is heirs property so deleterious to landowners? Well, chiefly because of the economic consequences to fractional ownership. Let me make sure my camera's on. There we go. All right. First thing, with heir property, there's always limited value and resource management. This is caused chiefly because profits when crops are grown on land, or perhaps timber is grown and harvested. Profits have to be shared from a legal standpoint in accordance with each landowner's fractional interest in the land. Therefore, if you're looking at an heirs property situation where you have between 20, 30, 50, 100 heirs, the profit sharing can become quite cumbersome, and the profits themselves can become quite small for all those fractional owners. And as a result, land is often underutilized, and the economic benefits of land ownership are really hindered. Partly because of that, financial institutions like banks and credit unions invariably refuse to loan money against heir property. As a result, the chief wealth-driving rationale for owning land is virtually defeated. And so that's another reason why it's so important to resolve heir property issues, so that heir property owners or property owners can realize the value of their land through lending from financial institutions. In addition, there's no way to convey the entirety of the property without a unanimous consent of all co-tenants who own the property. This can be very hard to achieve when you're dealing with a large family, when you're dealing with numerous interest holders in heirs property. And so as a result, it's very hard to achieve a large sum of money from family land when a sale is attempted. And then finally, and probably most importantly, heirs property is severely undervalued from a revenue standpoint, partially because it's so hard to profit from heir property land, and partially because things like tax payments can get swept under the rug with heirs property owners. Communities where there's a high concentration of heirs property oftentimes experience a lot of undervaluing of land, don't achieve a lot of revenues that other areas with smaller amounts of heirs property would see. If you look at a map of, let's say, the state of Alabama, you see where there's the highest concentration of heirs property, invariably that's also the lowest concentration of revenue generating lands. And so it can be really devastating, not just for family members, but also for the communities where their lands exist. Next slide. But we as attorneys can help heirs property owners and their communities realize economic empowerment from land ownership through resolving heirs property issues. So the next part of the presentation, we've talked about the problem of heirs property. I'm going to move into another maybe happier section, which is how can we as attorneys resolve these issues. A great tool that we have as attorneys is the Alabama Uniform Partition of Heirs Property Act. Valynda briefly touched on this a little earlier, but it is a valuable resource that we have as attorneys in the state of Alabama. Alabama's been quite proactive in generating laws that affect or positively affect heirs property owners. The first state to adopt the UPHPA was Nevada in the early 2010s. Alabama was one of the very first states to adopt the act. In 2014, we did so. The UPHPA has a number of positive facets to it. Most interestingly, I think, the UPHPA is the first statute to define heirs property. Before the UPHPA, the term heirs property was utilized mainly by sociologists and legal scholars, but it wasn't recognized at law. However, the UPHPA provides for a very narrow definition of what heirs property is. Valynda's gone through a good amount of what constitute heirs property in Alabama. Namely, any of the following of these three must apply. Either 20% of the interests are held by co-tenants who are relatives, 20% or more of the interests are held by an individual who acquired title from a relative, whether that relative is living or deceased, or 20% or more of the co-tenants are themselves relatives. Now, another really important feature of this definition that a lot of people overlook is that if a tenancy in common agreement, which we'll talk about a little later on, has been ratified, essentially a contract among the heirs property owners governing how the heirs property will be managed and potentially disposed of. If there is a tenancy in common agreement in place, from a UPHPA standpoint, from a statutory standpoint, that land is not considered heirs property. So that's another thing to look for when determining if the UPHPA might apply when dealing with heirs property issues. Next slide. Okay. Second, and probably most importantly, the Act essentially replaces the traditional partition in kind and partition sale options with a statutory preference for partition by allotment. And partitions by allotment are essentially court actions whereby a court gives full ownership to one co-property owner and orders them to essentially buy out the remaining co-tenants based on their percentage of ownership. So there's a clear process that the UPHPA lays out that must be followed in order for an existing co-tenant to buy out other co-tenants. First, the court will order that the fair market value of the property as a whole be determined. And then that fair market value is communicated to all heir property owners. And then the other heir property owners are given a period of no less than 30 days to object to that fair market value appraisal. Section 7, 8, and 9 of the UPHPA provide even more of a roadmap for how this buyout process will come about. The drafters stated that a rationale for a buyout provision was that it promotes efficiency within the court process. It encourages the consolidation of ownership, which is a real challenge in a lot of heirs property cases. And then they use this interesting quote in the comments to the statute. They say that essentially these legal mechanisms democratize the heirs property resolution process, and it essentially makes for a process that's, quote, used for family property owned by those who are wealthy and legally savvy. So as an initial matter, all co-tenants have to be notified of the request to buy out other co-tenants. And each co-tenant not requesting a sale has 45 days in which to purchase the interest of the petitioning co-tenants. And the required purchase price of the shares is determined by the fair market value multiplied by the petitioning co-tenant's fractional ownership of the entire parcel. The court will then notify all other co-tenants of the purchasing party's intent to buy and the price which will be paid for each heir property's fractional interest. And then the court will provide the purchasing co-tenant with at least 60 days to provide the required funds to buy out the other co-tenants within the property. What this does is it eliminates kind of the draw that we were seeing around the country, where you would have moneyed third parties who would swoop in, purchase a small share of heirs property, seek a partition sale, and then essentially buy out the rest of the heirs property owners at far below fair market value at a court auction. So by doing this, even though it's not a perfect system, it works to keep family land within the family, and it aids in empowering heirs property owners from an economic standpoint. Next slide. And then finally, interestingly enough, the Act also solidifies the partition in kind, so physical divisions of property as statutorily preferable to partition sale, the process that I just mentioned earlier, where you can have members of a family or perhaps a third party to request a sale and potentially purchase family land at far below fair market value. This is not a deviation from Alabama case law prior to 2014. Especially Alabama appellate courts have always stated that partition sales are extraordinary measures that should be avoided at all costs. And partitions in kind should be essentially sought out first before the partition sale. The UPHPA sets out that a partition sale can only be ordered if the partition in kind would result in great or manifest prejudice to the co-tenants as a group. Again, not a deviation from Alabama case law, but in practice, before the UPHPA, what a lot of especially trial court judges would do at a statewide level is they would analyze this issue of what to do with family land from a purely economic standpoint. And that's not entirely without kind of compassion. I mean, they weren't doing it because that they wanted to separate family members from their family land. It's just kind of standard practice that they would purely view partition from an economic standpoint. But what the UPHPA says is courts have to weigh a variety of factors, and no single factor would be determinative of what to do with land, but you have to go through the process of analyzing which type of partition would be best for the situation. Some of the factors include practicability of division, duration of time that the parcel of land has existed within a family, family sentimental attachment, so not just the tangible benefits that family members get from land ownership, but the intangibles as well. How land is being used and whether the cessation of such use would harm a co-tenant. Two things that really come to mind right off the bat. The court will have to look to see if there are residential structures on heir property land. The court will have to look and see if crops are being grown or if timber is being grown and harvested on the land. And then finally, a court will also look to see the degree to which co-tenants have contributed their pro rata share of associated expenses with land ownership. So again, while payment of property taxes and maintenance fees are not dispositive in determining how family land is to be divided, it's certainly something that should be weighed by the court. Next slide. So how can attorneys, and perhaps we have some law students on the call as well, how can we curb the effects of heir property? Valynda pointed out earlier the importance of spotting heirs property issues and even determining whether heirs property is indeed an issue. Oftentimes this requires a lot of historical research on the front end. And so even determining whether or not heirs property is truly an issue can take some time to determine. Simply, we can draw up an affidavit of heirship to prove the timeline of heirship if intestacy is really involved. We can file an action to clear up title. Importantly, we can utilize mediation, something I did a lot last year to try and garner some agreement about what to do with family land within the family. And then finally, it's very important that land be consolidated, perhaps through a land trust or an LLC, or as a last case scenario, establish a formal tenancy in common agreement so that heirs can agree on those kind of common points when it comes to how they'll maintain the land over time, and perhaps if and when they would ever sell the land. And then finally, attorneys can also and should also write wills in order to curb further fractionalization of land for future generations. Next slide. Understanding client goals are really important as well. Sometimes, and this is hard for kind of socially conscious attorneys like myself and like Valynda to kind of sink in with, but sometimes it's preferable to even not do anything, because sometimes when you're resolving your property issues, you have to notify a lot of heirs who might be otherwise unknowing of their ownership of family land. And so sometimes it can be quite disturbing to the peace to bring up some of these issues. Sometimes clients have very specific goals. Maybe they want to curb further fractionalization of their family lands, but they don't want to necessarily go through the time and expense and emotional taxation of going through what can be a very long process. And so they just want a will written out for them. But oftentimes the best alternative for family landowners is to really go the full mile with resolving heir property issues, with clearing title, with consolidating title in one particular entity, and preserving the family land for generations to come. Next slide. Again, mediation is one of the most important tools in the attorney toolkit when attempting to resolve heir property issues. I typically won't take on an heir property case unless we have one or a series of successful family mediation sessions where we can come to some kind of agreement on how lands will be maintained over time. I found that my mediation sessions, sometimes with very large families, is very successful. For instance, I had one family with two very clear camps, what they wanted to have happen with the land. We were able to come to a mutual understanding and meet in the middle, and the resolution process was made much easier, and it was much less emotionally taxing on the family. So it's very important that there be an open dialogue among family members with how they want the land to be maintained over time. Again, mediation is a form of alternative dispute resolution where, in my case, the attorney acts as a third-party neutral to essentially foster dialogue between the family members. The attorney, him or herself, is not coming up with essentially an order of what is going to be done. The family comes to that decision, but it fosters a lot of rich dialogue at the very least. Next slide. So the process of clearing title can be actually quite time consuming, but in many instances, it's a really important process. So in heir property cases, attorneys and clients should work together in locating a lot of historical records surrounding the property, including the most recently recorded deed for the property in question. In most, if not all cases, especially when you're dealing with a lot of heirs, the construction of a family tree is helpful and necessary in clearing title. And patience and historical research skills are often necessary in clearing a client's title to real property. Once a family and an attorney establishes a clear chain of title using previously recorded deeds and the construction of a family tree, an attorney will likely need to have the estate probated, sometimes multiple times. So the estate must be probated for each ancestor in the chain of title until it reaches the client. So for instance, if you're dealing with great-grandfather's land, you would have to potentially probate great-grandfather's estate, grandfather's estate, father's estate, down to client. This can take a long time, and it can also be quite taxing on your client's patience. So it's important to clearly set timelines and expectations from the front end. And then finally, long-term preservation of heirs property is key. The best way of doing that is consolidating ownership in an inorganic or organic source. So the creation of an LLC is a great way to consolidate ownership. An LLC will be formed. Each heir will convey their interest to the LLC, and then decisions within the LLC will be made not based on unanimity of heirs property owners, but a majority vote of heirs property owners. And I made a verbal mistake there. The importance of an LLC is you're consolidating ownership in that LLC, so that land no longer is heirs property. Instead, the former heirs property owners are now members of the limited liability company. So partition sales and partitions in general are really impossible to pursue in that way. A land trust can be created where interest will be donated to the trust. Trustee will be appointed. They'll act in the best interest of all beneficiaries, and the former heir property owners will be the beneficiaries. Also, land can be consolidated into one person. So if a family sees fit, and I saw a family just a few months ago where they decided this was the best option, they can deed their interests in the land over to one person, and that one person will then have a totally controlling interest in the land. And then finally, when all else fails, a tenancy in common agreement can be adopted and ratified. This is just a contract between heirs property owners, essentially governing how the land will be maintained and potentially disposed of over time. Importantly, though, this doesn't resolve heir property itself, because even though a tenancy in common agreement is in place, the property itself is still owned by tenants in common. So it doesn't defeat that tenancy in common. And then last thing, will writing. So a misconception I saw throughout my time helping people with heirs property issues, a lot of people believe that if they simply wrote a will, it would resolve their heir property issues. That's not the case, but it can prevent further fractionalization of the land, which is very important to do. So we should always offer will writing services to heir property clients that we see. Okay. Oh, and then finally, affidavits of heirship. It's a great tool as well. I didn't get to it because I see we're at time, but I'm sure we will include this in some of the materials we give our participants today. All right, and in closing, we hope that you'll look through the materials that we gave you. We are working on getting an air property manual published and out to you guys. So be on the lookout for that. I know Nell has everyone's information, and so we can include that in a later email. But it will have a lot of this information that we gave you today, just in greater detail, and can be a great reference for you in the future.
So I'll just ask some of the questions that have come in. Specifically, how does the statute treat illegitimate heirs?
For that illegitimate child, they would need to prove relationship to the decedent, and that could be that the decedent signed a birth certificate, that there has been a prior adjudication of that person being the father, a legal adoption, or the father has held that child out as his or her own, and we can get people to come in and testify to that to establish paternity some kind of way. Oftentimes we don't have that, and we don't have any kind of DNA record to really establish the link between the decedent and the illegitimate child. But if there are other heirs who are alive who are willing to go ahead and do that blood test or assist with establishing the paternity for the illegitimate child, then that person, once established, would have rights to the property as well.
Thank you, Valynda. And then what can a property owner do beforehand? And I think we did talk about this a little bit. This might have come in before you presented, Will, but any additional thoughts on what a property owner can do beforehand to unify the property interest and maintain interest in the whole?
Yeah, so obviously land interests will need to be consolidated, or perhaps a family can come up with a plan and they can kind of communicate that among themselves and include that in estate planning documents. I'm quite partial to the LLC. There are some positive tax implications, but also with some of the families I've dealt with, land trusts I've thought to be kind of problematic because the appointment of trustees can be quite controversial. And with the LLC, it really democratizes the process of decision making because within the family as a whole, it simply takes a majority vote to determine what to do or not to do with land. And in an interesting kind of way, I've found that comforts family members who are thinking about how they're going to maintain land over time.
Thanks, Will. And then these are kind of joint questions, like a two-part. What if all the co-tenants cannot be found or are known? And then what if the co-tenant doesn't want to sell or buy out the other heirs? Can they stall the process?
Yeah, so obviously finding co-tenants can be an issue. That was an issue for me. And my work last year, I was in all of my cases that I dealt with, and the max that I dealt with would have been just north of 30 heirs. So it's sometimes tough to find folks, but it wasn't impossible, and I was able to find heirs with a little bit of digging. Valynda, I don't know if you had any instances where you couldn't find heirs and had to move.
I have, because heirs could be all across the country, and so it can be very difficult to find them, especially when we're dealing with grandchildren and great-grandchildren, and your client may say, I don't know the name of that great-grandchild of my cousin. You know, it's a lot to ask of people. Luckily, there are organizations that are committed to doing heir search. And so if you are an attorney and you are trying to help a client, you may turn to one of those entities to actually do the air search property, the air search research for you to locate the heirs. Or it could be as easy as trying to get a hold of death certificates, trying to get a hold of obituaries to see who are listed as kin, and using the internet and using the paralegal to really help do some of this research for you. It is time consuming, can get into the weeds trying to locate an heir, and sometimes you just can't locate the person, and that's a problem. But there are resources out there.
And just to kind of answer the second part of that question and kind of tie it into what was just asked, yes, heirs who might be unknowing that they are part owners in heirs property can derail the process. And so that's why sometimes it's kind of risky to reach out, and sometimes certain avenues of heirs property resolution can really be risky for families. So it's important to understand client goals, and it's important to be to use a lot of discretion, I would say, when attempting to resolve some of these issues.
I've seen where there's someone who thought they were an heir living in property, but they were not a rightful heir to the property, and they were living there rent-free, mortgage-free. And so you may not want to disturb that situation. You may just want to stay there and not try to search for anyone, because you will be opening up Pandora's box when the heirs finally find out that they have an interest in the property and you do not.
And I dealt with a thankfully friendly heir who was born and raised in Los Angeles, and came to learn that she was the part owner of air property estate in Montgomery County. And of course, when you hear, oh, I'm a part owner in land, you think, oh, well, this could be worth a lot of money, when in fact, her tiny little fraction of ownership was very, very small. And so she could have potentially caused a lot of harm for the other heirs had she pursued other legal mechanisms in the air property process.
Thank you both. And then I think that this is a good kind of closing question. I know a few have come in, but for private attorneys partitioning among multiple family members, and maybe only a few of the family members are low income, can the attorney's fee be paid out of the partition sale?
Valynda, do you know the answer to that question?
I haven't had this issue to come up, and so I would say it's possible, yes, it could be paid out of by the partition sale. Again, that's a discussion to have with the clients that you are representing. And if you're doing it pro bono, maybe you want to waive your fee, but you can definitely ask for it and see if you can get it.
Thanks, Valynda. And then we have a lot of comments, a lot of excitement about the air property manual to come, and a lot of thanks for both of you for presenting and sharing your expertise today. So thank you. Thank everyone for attending. I hope you have a safe weekend and stay warm. Take care.
Thank you.
Thank you. Thanks, Nell.